My name is Adam Saven. Welcome to our YouTube channel. I'm going to be going over 10 things you're going to see as you walk into your first trial. We're going to cover that stuff, so stay tuned. All right, quick pause. Make sure you guys watch to the end. At the very end, I'm going to talk about what not to do in trial. Probably more important than this video. When I walked into my first trial, I had no freaking clue what I was about to do. I had never seen a trial before. I'd never been in a trial school. And I actually went to YouTube to try to see if I can learn how to be a trial attorney. And I walked into that trial. I fumbled the whole way. Luckily, the judge, after yelling at me a few times, and I told the clerk, this is my first trial. I think she told the judge, and he was a bit nicer to me on the second half. That's what we're going to do. I'm going to kind of walk you through some of the most basic steps of at least what's going on in trial, and then later on we're going to go over those steps in a lot more detail. First thing up, right before you walk in the doors of your trial, you got to line up your trial. And what I'm talking about is you're going to have to put together your trial binder, your exhibit books. You're going to have to work with all your witnesses and expert witnesses, make sure that they're available to come in and kind of coordinate the calendar system. The things we just talked about, I could talk about those things for hours and some strategies and tips. This video, we're not going to talk about those things in that kind of detail. I'm just giving you a quick overview. We'll do that stuff later. Number two, after you're prepared, you're going to be arguing the motions. You need to know your case. These motions are what are going to determine what evidence comes into your case and what evidence you can keep out. So you got to be prepared. This is your first opportunity usually to make a good impression with the judge. And so when the judge rules on these motions, we usually don't get too aggressive with the judge because we don't want to rub the judge the wrong way right before he calls out the jury and right before we have a whole bunch of other stuff. Number three, we're going to talk about mini openings. You know what? Can I stand up? Can we move this thing up? All right, so I just stood up. Actually, as a good side pointer, whenever you're doing depositions or doing anything on like Zoom, stand up. It just kind of makes the information come out a little bit differently. Before the jury gets questioned by you, the judge is going to give you an opportunity to do what they call a mini opening. It's like 3 or 4 minutes. I've had them as short as a minute to 2. I've had them go 5 or 6 minutes, but really it's just a really short dialogue. It's your first opportunity to talk with the jury. You have to take advantage of these. It's your first chance. And the courts really can't prevent you. The law now says you get to do it. It's your first chance to break the ice. Don't try to tell them all these like crazy facts about the case. Just use it to try to connect and just show me a real person. Just be very honest and straight and say, this is what the case is about. I'm going to be asking you guys some very personal questions. Here are some of the facts, the things I'm concerned about in the case. And that's pretty much all you got to do. But you absolutely take advantage of the one opportunity to speak freely to the jury before you start questioning the jury in the next step. Number 4, if you've made it this far, you're in trial, jury selection. This is basically where the rubber meets the road. You got to really just connect with the jury. And what's really tricky about it is all these judges, they do it differently. So some judges are going to say, talk to 12 jurors at a time. They'll put 12 in the box and you get to go through those 12, eliminate some of those. And then I've had judges make us question the entire room. Like I've had a room of 40 to 50 jurors and we've had to question the entire room at one time with unreasonable time constraint. But basically, we'll go into more details in another video of picking your jury. Make sure you question every single juror before you sit down. Don't let your time run out. Number 5, probably the second favorite thing for me, it's opening statement. And not to be confused with an argument. My first trial, I actually got in trouble because I thought it was opening arguments. I don't know why I thought that, but I went in there arguing the heck out of the case. I got shut down by the judge and by the defense attorney. I said, Your Honor, this is opening argument. He said, no, it's not. This is opening statement, argument at the end. I learned real quickly to say the facts. But with an opening statement, you can say stuff in an argumentative manner where it's still just a statement. And we're going to teach that in another video where I give tips of how we do our opening statements and how we frame the case and also what evidence kind of comes in first. The whole purpose of an opening statement is to give the jury a roadmap of the evidence that they're going to see in the case. That's the whole purpose of it. You are, but you aren't arguing your case, but you're letting them know what they're going to expect. You're getting them interested, and if you do it right, you could win your case in opening before there's any evidence that's introduced. Number 6, and this is after the defense also gets to pick their jury, and they get to do their opening as well, but then you go on to number 6, and this is plaintiff's case in chief. Remember, you've got the burden. You have to put on your evidence. The defense doesn't have to put on any evidence. So this is your chance to line up your witnesses. This is the crux of the case. We're showing the jury what this case is all about. We want to call some really strong witnesses first to kind of win right out the gate. Sometimes that's going to be your client. Sometimes that's going to be a defendant, a corporate defendant that has some really damaging testimony against them. It might be a damage witness. And usually in the middle, you're going to start to kind of bury the witnesses and finish with your strongest expert to basically build the damages for your client. And you're going to be putting on all this evidence. Now, during this process of your witnesses and trying to get this evidence in, you need to make sure, as a practice pointer, that when you introduce exhibits and you introduce these exhibits for the jury and for your witnesses, you need to get them into evidence. And you have to get your exhibits into evidence before you rest your case. Otherwise, you have no exhibits. The jury's going to have no exhibit. So here we are, number 7 on the list. Now you rest. So I'm going to sit back down for this moment because I'm resting my case. I made sure I put all my exhibits into evidence, asked the judge to do it, or I reserved my right to do it at a later time, which you can also do. And so we sit down. We take a break. Number 8, you sat down, you just rested your case. Now the other guy, the defense and the defendant, they get to put on their case in chief. And sometimes they even get to do their opening at this time, where they reserve their right to do an opening at a later time. At the bare minimum, what I usually see is at least a defendant get on the stand, or a defendant representative, and we'll see, a couple experts from the defense. They put on their case. And what your job here is to not lose credibility. Make sure that these experts that the defense is bringing doesn't torpedo your case. So you have to be really prepared. This is probably where we get almost the most prepared during trial, is to pick apart the defense experts. We need to make sure that we can go in there like a guided missile. We have 5 to 10 or 15 minutes. We don't want to take too long. We're super prepared, and whatever they say that harms our case, we're ready to basically attack it head on. The defense does their case in chief, and then the defense is going to eventually rest. Number 9, closing argument. Every lawyer who goes to trial, this is what it's all about. Statistically speaking, you've already kind of won or lost your case before you get the closing argument. We love closing arguments. That's where the gloves come off. We get free reign. There's always going to be some golden rules and things that we can't violate as far as arguments, but you get to really hammer home at the evidence, tell the jury about the evidence that they just heard. So the way I look at closing argument is we're putting the evidence into context, because without context, a lot of that evidence doesn't make any sense. Opening up the jury's eyes. See, because a courtroom is just like a little box, and they're just kind of looking at it in this little box, and we gotta open their eyes to see the big picture. A lot of the stuff that the defense does and these defense methods to try to defeat us at trial, they don't make sense. The defense starts to fall apart, picking out dates that your client missed doctor's appointments or had a month gap in treatment, because in the real world, that happens to all of us, and that happens to our clients. And if you can explain these things to the jury, ultimately, we want them to see your client's case through their eyes and walk in their shoes. Closing arguments is the best part. The defense gets to go right after you and do his closing argument. And last but not least, we get the final word, and that's called rebuttal. And rebuttal is amazing. You just did your closing, defense did their closing. If you're like me, I'm sitting down in the chair when the defense is doing their closing, eager to get up. I usually like to save 1 or 2 of my best arguments for the rebuttal. You always want to keep something. And then I'm just viciously taking notes during the defense closing, 10 or 15 minutes long. Don't make it too long. You're not going to convince the juries one way or the other in your rebuttal. Don't make it another closing. And it's really hard to keep it short. Show the jury your emotion. Show the jury that you really care. This is not just a case, and what the defense attorney just did upsets you, disrespects your client, disrespects the system, and let your emotions come through. I usually try to keep my cool in trial, very calm and professional, and the rebuttal is kind of where I let my emotions out. And I even sometimes apologize to the jury. After you sit down, where you hopefully crushed the dreams of the defense, I kind of skipped a step earlier. The judge will then kind of read those jury instructions to the jury and then send them on their way to deliberate. And that's just the waiting game. You get a call within 5 minutes to 30 minutes, it's probably problematic. The longer the jury's back there, statistically, is better for the plaintiff. I promised you at the end what I think is going to be really important, what not to do. I really wish that I would have learned this a lot earlier in my career. I was watching all these lawyers and I was getting their PowerPoints, copying their arguments, copying their presentations, trying to just do it their way. And I found myself in trial giving these ridiculous hypotheticals and ridiculous scenarios and showing pictures of like the Mona Lisa and a fighter jet and doing all these things that a lot of great attorneys have done and been very successful with. Looking back now at the progression after all these years and looking at kind of what we do now, you got to just be yourself. Do it your way. I finally learned to just come up with my own examples that made sense to me, coming from your own life experience. That's why those things worked for those other attorneys. They created them. Come up with your own system. All the things we talked about, I'm gonna go into in a lot more detail. Hopefully I can continue to offer some content that'll help any attorneys who wanna get into the courtroom. If you like the video, give it a like. If you wanna follow for more videos, hit the subscribe button. You know what that does. Thank you very much for tuning in.